Have you been running a business that is projected to fail because of low returns on investments? Are you a creative entrepreneur that has had your creative masterpieces stolen or copied by others? Maybe you are a person that has reached a place in your journey where you feel like giving up on your goals and objectives. If so, keep listening, because in this episode, I will discuss the importance of protecting your brand, name, inventions, and overall creativity, thereby giving you a new outlook on doing business in today's ever-changing marketplace. Welcome to the Educated Natural Podcast. I'm your host, The Educated Natural. This podcast tells the unadulterated truth about the daily journey of being an entrepreneur and content creator. Here, you will find details about intellectual property protection, business positioning, and strategies for your overall success. Now give it up for your host, The Educated Natural. Hello, everyone, and welcome to another season and session of the Educated Natural Podcast. I'm your host, The Educated Natural. I am super excited to be bringing today's episode to you today because I have a very exciting guest with me today. Honestly, this beautiful woman here needs no introduction at all. But in case her beautiful face has not been alert enough for you, allow me to tell you exactly who this wonderful woman is. But in the meantime, I want to see if anyone in the chat can tell me who she is or anything about her. But if you can't, let me give you a little bit of a hint. Her name is Fraline J. Allgaier, and she is an intellectual property law attorney out of Illinois. Listen, if you're in the Midwest, you need to put your listening ears on because she is a force to be reckoned with. She is the founder of Allgaier Patent Solutions. You can find that at www.allgaierpatentsolutions.com. She represents clients throughout the United States who need legal assistance with regards to patents, trademarks, and copyrights. Listen, if you are a business professional and you know you need to protect your intellectual property, you need to share this out immediately, especially if you are an inventor. But let me continue on and tell you a little bit more about my featured guest today. She has a BS, which is a Bachelor of Science in Biology from Texas Southern University. Oh, but that's not all. She also has her MS, which is a Master of Science in Biology from Texas Southern University. Hold on to your hats, everyone, because that's still not all. She's earned her JD from John Marshall Law School. Now, if you know anything about law schools, you know about John Marshall. Oh, but that's still not all. She also has practiced before the U.S. Court of Appeals for the Federal Circuit and the U.S. Patent and Trademark Office. Now, I told you, this is the Educated Natural Podcast. And as you know, my vow to you is I will never leave you uneducated. So when I tell you I bring the best of the best to the podcast and to any show that I do, you better believe it. But I'm not going to sit here and tell you all about my guest because I want her to tell you about herself. So everyone join me, put your hands together and welcome Attorney Fraline J. Allgaier. Welcome, Attorney. Thank you for being here.
And thank you for having me, to talk to your clients and to discuss their intellectual property needs. Thank you so much.
Absolutely. I'm super excited to be here. I was telling my other people that I talk to outside of the social media arena that I was super excited to be able to connect with you and have you here because to me, you seem like a unicorn because there aren't many patent attorneys there definitely are even less African American patent attorneys and probably even less female African American patent attorneys. So I'm super excited to just have you here. Like, I literally just want to grab my notebook and just sit back and take notes.
Yes, and I would agree with you. It is a unicorn status, indeed, but unicorn in terms of STEM, but not in terms of reachability. So for anyone that is listening with a science degree, an engineering degree, this is something that's certainly doable. You don't have to go to law school. So yes, it's all doable. Thank you so much.
Yes, thank you for being here. Thank you for saying yes to the opportunity. And also, I have to give a huge thank you and shout out to Jay, your brother. And on YouTube, he's known as Juicing with Jay. So thank you, Jay, for making the connection.
Yes, yes. He'll be excited to see me here. And I know we're competitive. He's a gardener, but I'm
Yes.
equally, into gardening as well as, as he is. So we're competitive in that regard. So thank you, Jay. Thank you.
Oh, wow. So see, my brothers and I are the only ones that are sibling competitors. So I love hearing that.
Yeah.
So how was it growing up with Jay as your sibling?
He's what you see, he's authentic. He works hard. He's disciplined. He's just as focused at home as he is at work. He loves gardening, but he works just as hard, in his professional career. He's always been a hardworking young man. So what you see of Jay today is not something that's developed overnight. It's something that he's had his personal, as his personal obligation, with in terms of how he does his work, his gardening, and raising his kids, and also, with his wife. So what you see with regards to Jay on his YouTube channel is always been 100% Jay. So I'm super proud of him. Yes.
No, that's great. That is great to see the love between siblings like that. That is a great, great thing to see. So, hi, Jay. Thank you for the connect once again. Now, Attorney Allgaier, there are so many questions surrounding intellectual property, especially in the age that we live in today, where it seems like since the issue, let's just call it that took over the world in 2020 and we're still dealing with today, a lot of people seem to have come out of the closet with so much creativity, things that they didn't think they could do prior to the changing of the world. What has it been like for you being a patent attorney? Have you seen an influx of inventions and patent filings, or what has life been like for you?
I agree with you. There's been an influx. It seems like with lock-in, with families staying in, and not just families, but individual inventors, business owners working from home, having a little bit more free time to think, inside of the home. I saw most definitely an influx in clients coming in with ideas. Nothing, I would say, out of the ordinary. You would have ideas relating to small mechanical devices from clients, ideas with regards to mobile apps, coping with COVID, using a mobile app, for example, to cope with COVID, developing clothing lines, to sort of represent that lockdown mindset or a current status of being in lockdown. So a plurality of ideas sort of rolled in from all over, not just the United States, but also over the world. Folks looking to protect these ideas and looking to fund these ideas if those funds were not readily available. So yes, most definitely an influx in ideas coming in. Sometimes, at least initially, overwhelming, but I wasn't terribly surprised. I'd heard that some businesses slowed down. Restaurants, for example, were closing down. While businesses closed all around, I still saw innovation coming in. Yes.
Yes, there was a lot of innovation. Even, personally, I started to awaken on the inside with so many different ideas, and just like this influx of creativity just took over me, because it's like you didn't have those outside distractions anymore because you couldn't go anywhere. So it gave me the opportunity just to kind of reconnect with myself and try different things, and definitely gave me the opportunity to study, to read up on protecting my own intellectual property. And I must say, I have heard so many stories from other creatives where during this time we're in now, the things that they created, a lot of people are finding themselves being either copied or stolen from or counterfeited. Have you had to experience that in your office, where you've had to be faced with that or fight for another creative masterpieces?
Oh, yes. And, I would say that most inventors, let's say they're highly sophisticated, meaning that they had an established business, patents, as a part of their business, they are able to hire attorneys to conduct infringement searches, meaning that using the details of a product, let's say I'm talking to a small individual inventor with a, container, a plate, or a new design for a container. They would search the patent database, the public domain, for infringing products. So this infringement search takes some wherewithal, some money, and some expertise to be able to make that determination. So I would say the more highly sophisticated clients can afford these types of services, because most attorneys or patent search agencies that offer infringement services, would charge upwards a couple $1,000s, for an infringement search. So on the one hand, you might have an individual inventor with an idea, but no funds, to start off, let's say, with a prototype. They might have an estimate for a prototype, $50,000, $60,000 for a prototype. So when you have a more sophisticated inventor, they've already invested thousands of dollars in the product, in the marketplace, in the business. They are more likely to then seek out an infringement opinion and then look to cease or stop the production of the infringing product. So just finding out if it's infringing, is a costly process. And I would say for most individual inventors, they'd rather start off with exposing what they have as opposed to protecting what they have.
Good point. Yes, that's true. A lot of people want to just put it out there and not protect it. And I think that's what gets a lot of people in trouble, because from what I've heard, and please correct me if I'm wrong, once you put it out there, it's like almost like it's up for public grab. And now you're having to fight against the ones you're saying are the infringers. Now you have to prove your side versus their side. Could that be a very tedious process based on your experience?
I understand it to be a tedious process, depending on, as I mentioned before, more sophisticated clients are likely to protect their intellectual property. But let's say I'm just sort of an inventor out there without the wherewithal to understand, okay, patent pending, the patent pending process. It on its face, it might appear tedious. But on my end, what we're able to do is have an intake process of you disclosing exactly what you've done so far and in what capacity. Let's say you're at a beta stage for an app, or let's say you're a drafting stage for a specific idea, or the idea is just in your head. If it's just in your head and you're talking about it, or let's say we're talking about it on this platform, that would not constitute disclosure depending on what the idea is. So based on the law, we can certainly take a look at what you have, what you've disclosed so far, and where are you going with the product, and give you a good indication of where you are legally with regards to the status of the product. It's not just how it looks, but it ultimately what the final product looks like on the store shelf, in someone else's home. So the idea, what's in your head, and what ultimately happens to the product are two different things. And then again, within the A and the B, the finished product and the idea, is a legal process for protection that has its own, standards for disclosure.
Wow, that's amazing. Listen, everyone, if you haven't already, make sure you check out her website. It's running there across the screen. Once again, that's www.allgaierspatentsolutions.com. It's right there on your screen. Those of you that's able to see us on our podcast channel, which is under the name The Educated Natural, all you have to do is go to YouTube and you can actually enjoy the actual live recording of today's episode. Those of you that's listening to us on Apple, Google, Spotify, iHeartRadio, and whatever your selected podcast platform may be, make sure you check the notes below. All of her information will be there, as well as mine. In case you want to connect with either one of us, we welcome you to do so, especially if you want to find out how you can protect your intellectual property. This is where you should go. Now, let's go back, Attorney Allgaier, and let's go back to how you decided, and at what point did you decide when you were in college that you wanted to be a patent attorney? I would love to hear your beginning story.
When I was growing up, I enjoyed writing, and I understand the legal process to include quite a bit of writing, not necessarily dictation, but analysis, writing. And in undergrad, I had several opportunities to conduct research at institutions outside of Texas Southern University, for example, at the Environmental Protection Agency and at UC Berkeley, as an undergraduate student. So in the process of working, working or consulting or research, with research partners, I would write protocols, papers, and scientific presentations, for example, that would require a tremendous amount of writing. And that's always been something that I enjoyed. As a student, for example, at Dorsey High School in Los Angeles, I was the editor-in-chief of the school newspaper. And, not only writing, but also competing in journalism, throughout the Los Angeles area. So in that regard, writing was something that I enjoyed. I enjoyed putting thoughts and ideas to paper. And I thought, okay, patent attorney would be, given my science background, sitting for the patent bar would be the best area of practice for me. It's not highly oppositional, and any opposition is, something that could be resolved on paper, based on how my style, my legal style, my writing style, in terms of presenting, for example, a patent application. Yes.
Wow. Yeah. Now, I've heard and read that not every attorney that goes to law school goes that extra mile to go into the patent side of things. How did that work for you? Because I know there's like a special exam for patent attorneys that other attorneys don't have to take.
Yes, for all the young people listening, for example, if you have a degree in biology, chemistry, let's say you're pre-med, let's say you're into interdisciplinary health sciences, let's say you're engineering, what you would do, before even going to law school is get your transcript evaluated for, or perhaps even if you log on to the United States Patent and Trademark Office and research the requirements for a patent agent, they're provided all of the classes, chemistry, physics classes that are required. Chemistry and physics just being two examples of the types of sciences that they're looking for to evaluate your transcript. So you can do your own pre-evaluation and then have your transcript evaluated by the patent office to be able to sit for the patent bar. And then later, if you do attend law school, then become a patent attorney. So the process might seem elusive, but as I mentioned earlier, it's much more transparent than you would know. But obviously I'm here to then clarify that it is possible. It just basically starts off with that background, a scientific background. Gotcha. Not necessarily that you would have to have the background to write a patent application. But I guess there's this idea that if you're in STEM, that you're perhaps much more able to understand the various types of technologies that would be presented in a patent application.
Wow, that's amazing. Now, is the patent exam much harder and much more in-depth than, let's say, your regular bar exam?
Okay, so the patent bar exam is testing sort of the types of procedures that would be required for a patent application. The steps, for example, if we're starting off in the primordial stages of the application, there's a certain amount of United States code requirements for the application, and there are code requirements for the prosecution of the application before the United States Patent and Trademark Office. And there are also procedures required for appealing certain, examiner opinions with regards to the patent application. So it's more of a procedural exam, focusing on national and international patent filings and procedures. So the process is different. In law school, you're studying contracts and criminal law and estates and trusts and corporations, on the law governing these types of legal concerns. So the patent office is more concerned with the international and national requirements for the prosecution of patent applications.
Oh, okay. Now I understand. Okay.
Yes.
Got it. Wow. I didn't know until after we had our pre-discussion that patent attorneys had a different exam. I thought that all bar exams were created equal. So thank you for the information. I had no idea.
Yes, and most people, would not know it, because it's not something, that's highly advertised,
Right.
and as you mentioned before, it's sort of, you're a unicorn anyway, so no one knows you exist. And so understanding this
Right.
process but it's the more, if you're interested, it becomes more and more transparent what your requirements would be, what a student's requirements would be to enter the process.
Wow, amazing. So since taking the patent exam and starting your practice, what has your legal experience been like?
I would say I'm independent. I'm independent, and every client comes with me for the duration of my career. So, for example, if you file a patent application and you're a patent inventor, there are certain maintenance requirements at least 3 intervals during the life of the patent, where you're required in most cases to have a patent attorney to prosecute certain maintenance documents, to the patent office. Similar to a trademark where you have certain maintenance requirements and an attorney required to conduct an analysis of your samples to show your continued use of that trademark. It's similar with regards to patentability, and if an inventor finds that their patent expires, then the patent attorney is then required to revive that patent application. So once you walk into my office, the relationship begins. I wouldn't say it's a highly complex relationship. I start off as simple as possible, as understand, to make the process easy.
Right.
For it might not be easy on my end in terms of prosecution, but certainly giving the inventor the feeling that it's doable.
Okay.
And an honest opinion with regards to the art.
I
Art
understand.
meaning the idea, because sometimes inventors might be way, in another sphere in terms of something we've never seen before, but we make it as easy as possible.
Well, everyone, I hope you have your listening ears on and you have your pens and papers out, because now we're going to go into the session where we're going to look even deeper into patents, because maybe you are an inventor out there, maybe you have this idea and you're just not quite sure as to what your next step should be. And that's why Attorney Allgaier is here with me, so that we can get you on the right path and make sure you're taking the right steps to ensure that your patent process is a lot easier than probably you coming up with the idea itself. So, Attorney Allgaier, let's say I'm an inventor, I have this great idea. What should my next step be?
I would say most definitely talk to a patent attorney, because you don't want to start talking about the idea. You don't want to sit on the idea. You would want to make sure that the idea is indeed patentable. So the first step is to talk to a patent attorney to find out if you can patent what you have. You're comparing your idea to a patent database of millions and millions of ideas, as well as ideas not just in the patent database, but also in the public domain, which is how a patent examiner looks at your idea. It starts off as an idea, ends up on paper, but a patent examiner is provided directives to not double patent, meaning that you're not issued a patent by virtue of coming up with the idea. It goes through an examination process that could last from anywhere from 6 months if you are let's say someone 65 or older and are filing a petition to make your application special, and examined ahead of time. So anywhere from 6 months to 3 years of examination. So the patent office or a patent examiner could be silent for the first 3 years of submitting a patent application. So given that time frame, your best option, if you have an idea, is to start the process. And if, let's say, we're looking at an individual inventor, with not a terrible amount of money or a lot of money, I would say there are opportunities, to still get the ball rolling at the patent office as a patent pending status. But a patent attorney can provide direction, the best direction based on your history, based on your current situation, and based on your intent, for this idea.
Wow, that sounds great. That sounds great. As a patent attorney, I know that you're probably approached by many people with ideas and different things of that nature and inventions. How does a person determine whether or not their invention is patentable?
I would say there's no way to make that determination on your own. So this is not something, an inventor should sit at home and say, oh, it's patentable or not patentable.
Right.
Patentability is determined based on the United States Code for patent applications. And if your patent is issued, you're given a patent issued patent number and certificate, and it becomes a part of the patent office records by virtue of a process. So if you have an idea, the first step is to keep it confidential. And if you share the idea, sign a non-disclosure agreement, but first talk to a patent attorney, with regards to the idea, because you could be looking at something that's already invented and you wouldn't file for a patent application. If it calls for a design, and we all know new designs could be new bicycle, new chair. The chair isn't new, but the design could be new. Right. So talk to a patent attorney if you're interested, and really first understand the patenting process. If you're a pro bono status, meaning that an attorney has evaluated your status to be pro bono, there are classes that are available for individual inventors to complete before coming back to the patent attorney. So there's a process to it. It's a step-by-step process. And as far as your idea, there's an intake process to make sure that your idea isn't just something that we think is not new, but based on a series of questions, intake questions. What are the alternatives? Here's your idea, but perhaps you have alternatives to the idea, but not just what you think it does at this moment, but what you anticipate, or having alternative versions of what you have.
So for people that are wondering about whether or not their patent is patentable, and let's say they go the extra mile and they have a prototype, mm-hmm. and they contact your office, financially, what are they looking at when it comes to filing for a patent for their invention?
Okay, so typically a prototype, given the USPTO procedures for patent applications, for example, you have an idea and you went and, spent money on a prototype. I would say from idea to prototype, there's a search missing, right? So you've invested $20,000 on a prototype, but is that mm-hmm. prototype something you're able to protect? Is that prototype that you've created yours, or is it a copy of someone else's idea?
Great point.
Right. So once you have that idea, you have to make sure that you secure a patentability opinion. So you have an idea, write it down. What are the steps necessary to practice this invention? Do I have sketches? Do I have, if you made, for example, a prototype at home, just to sort of give a body or form to this disclosure of your idea, what is it? What does it do? And we search that idea and give you an opinion to let you know if the direction in which you should move with this product. Should you get a prototype? Should you file a provisional patent application? Should you file a utility patent application? Is it calling for design? Meaning that you've created this handmade prototype, but you sort of created something that already exists, but the style is different. You sort of presented a stylized format that could be protected as a design. So in the first stages of your idea, seek out legal assistance, get an opinion. Is it something you can do? Is it something you can, is it legal, what it is that you're doing? And if it is legal, how to proceed in terms of patent pending. I think inventors like that term patent pending, and it's certainly something that's achievable depending on the idea at a lower cost.
I love that idea. I love that advice as well, because some people want to just jump into it, and without doing the research prior to, that could be a lot of time and money wasted. So at what point during the process would they contact you? Is it after they come up with the idea? Did they go to the attorney then? Or at what point? Because we want to make sure we do things in the right order.
Exactly. So as soon as, if you have an idea and if you're serious, the thing is, you do have to want to work with this idea. If you like this idea and you're serious about it, you see yourself in business. So really do a self-evaluation as to the idea. Make sure that it's really something that you're, prepared financially for a patent application, for, let's say, a provisional patent for a patent search. A patent search, patent application, provisional patent application, and also selling the product. It's not just enough to have a patent. There are 99, I want to say 99% of patents in the patent database you've never seen before or heard of before.
Right.
So the idea, any patent examiner will tell you, you don't have to argue with me left and right about patentability. What are you going to do with this device? Are you selling it? Are you going to make money back? Are you going to recoup your costs? You're going to build a business over it. So that's the first consideration. And, a patent attorney can provide additional directives with regards to the idea.
I love that idea. I love that idea, because even with trademarks, I find out that a lot of people, especially in social media, they think it's okay to just put their hands on other people's things, and the creator behind it gets upset. But I like to tell people, if you didn't do at some point your own research on both sides, it could be a battle to the end. And it almost seems like it could possibly lessen the, I don't want to say effectiveness or the power behind the patent, the trademark, or etc., if you don't do your research first. Because I ran into that myself when it came to my own trademark, against the people that just thought, okay, I see it out there, I'll just use it, not realizing that I had already taken the steps to go and protect my own IP. And now I'm having to tell them, you have to take these things down. So for patent wise, if someone finds that something they're working on is being used or copied by someone else, and when they did their research on it, there was no one else that had the idea, what steps can they take if they wanted to contact you about this? What can they expect in that situation if they contact you about an issue like this?
Well, the USPTO system is a first to file system, so I'm, a big proponent of get it in the patent office in whatever form you have, and I've seen this over and over again, where something goes viral, there's a product that goes viral, or someone's using a trademark. And we're not doing this like in the older days, old days in the neighborhood. We're on Facebook, where the whole world sees it. We're on Instagram, where the whole world is seeing your product. They're seeing your work. They're seeing your style, how you do things. So I would say that I'm rushing to the patent office on many occasions with information to kind of get that patent pending status moving, and also then working towards a prototype and a utility patent application. The provisional patent application is just sort of documents, photographs, or write-up, sometimes screenshots of an Instagram page and a brief description of an Instagram page sent over to the patent office for patent pending status. And we can get that within a matter of minutes, a patent pending status. But that's just a patent pending status that would need development to what your goals are for this product. And I would say a provisional patent application, let's say you submitted a prototype or a photograph, or, we're not talking trademark, we're talking a product, photographs of a product submitted as color to the patent office. a provisional patent application is not examined. An examiner does not take a look at the information. What happens is the documents, your photographs, your description are kept in a docket, patent pending docket for 12 months until you're able, 12 months maximum until you're able to file a full patent application with the appropriate patent drawings and description, claiming utility, provisional to that, claiming priority to that provisional patent application.
I'm so glad you brought up provisional applications, because there seems to be like this, I guess, a discrepancy or an argument or so, or confusion definitely, about the difference between provisional and non-provisional applications. So if you could go a little bit deeper into that, because I want to clear up that discrepancy between the two.
Okay, so provisional patent application is more where you're in the idea phase. You come to my office, or Attorney Allgaier, have an idea for this product, no prototype. It's just sort of an idea. I do an intake where you describe the idea, and you can sketch out the idea, and those sketches and sketches, photographs, and description of your product are submitted to the patent office as an idea. So we try to get as close as possible to what the final product would be to be able to claim priority to that product. Let's say your new idea is a new chair, but all I did was submit sort of a flat surface to the patent office. Obviously, there's a difference between what I submitted and what you ultimately came up with. So we try to create something as close as possible to what you anticipate this product to be able to say, this is a proper priority claim. To your provisional patent application. So a full utility patent application would be sort of what you fully anticipated that product to be. And a provisional patent application is more of the idea phase. So valid only for 12 months. And within that period, you can use that period to advertise your product, to prototype and start marketing your product within that 12-month period. But most clients would need to know that it takes approximately 6 to 8 weeks to write up a full utility patent application. So you're not running into my office on the last day of that 12-month period. You would have to give an attorney, at least for me, 6 to 8 weeks to write up that patent application.
Great advice. Great advice. I hope everyone is paying close attention to what Attorney Allgaier is telling us today, especially if you are an inventor, because you don't want to fall on the wrong side of the USPTO. You don't want to lose your invention because of your fatal mistake. So she has given out some great information to us all for free 99. So listen, pay attention, because this is an actual patent attorney, okay? And if you've ever had to contact an attorney, their fees are not on the low. So please, if you have questions about the process, if you have questions about patents, I encourage you to leave them below wherever you're seeing this video or listening to this audio. Please feel free to contact her. I'm going to give her a moment now to tell you how you can contact her and get you all on the right road to success when it comes to your inventions, your patents, your trademarks, and your copyright. So please, Attorney Allgaier, please tell everyone how they can contact you.
You can contact me at any time at my website, Allgaier Patent Solutions. I do provide free initial phone consultations where we can discuss your idea by virtue of you filling out an intake form and a non-disclosure agreement. We're able to discuss the financial framework for your patent application. I do refer clients to, for example, the Chicago Inventors Organization here in the Chicago area. It's an used to be an all African American inventors organization. It's since grown. They have a vast, they have resources for inventors with regards to possible licensing, for example. But for the most part, the Chicago Inventors Organization provides counsel in sort of with other inventors, where you can exchange ideas, talk about where you are in the patenting process, where you are in the, without necessarily sharing your idea, without, first signing a non-disclosure agreement.
Right.
So they're in the business of helping inventors. So sometimes I refer clients to the Chicago Inventors Organization, depending on how serious they are about the idea. You don't have to be serious to call me with your idea. You could just be in the idea phase and need some guidance on what to do, or perhaps you've seen the product, you already have a patent and you see a product in interstate commerce, something that's very similar, whether it's a trademark, there are, possibilities for trademark as well. You're using a trademark, but then you see someone else using the trademark. These are all concerns for not just you, but a lot of business owners. So, feel free to contact me for a free consultation to discuss these ideas and what the best steps would be, to sort of secure your IP. If you have a logo that you've been using that you did not protect, if you have artwork, for example, these are all areas of intellectual property. Perhaps there's a product, like a hair product, for example, or a food item of food. Everything is protectable if you're offering something new in interstate commerce.
Sounds great. Thank you so much, Attorney Allgaier, for sharing your information with us. Now, everyone, make sure you head over to her website that she's already told you all about. And those of you that's watching this live on YouTube or in the pre-recorded format, make sure you pay attention to her website that is flowing across the screen, as you can see there, just in case you forget after you hear this episode where to contact her. And of course, something goes wrong and you completely forget who she is and where you can find her, you can always reach out to me at www.theeducatednatural.com. And of course, on all social media platforms, I am there as The Educated Natural as well. Now, Attorney Allgaier, you got to mention your social media because, everybody's on social media.
Yes, I'm on Facebook. I'm on Instagram. And I'm on YouTube, but most importantly, just call, just pick up the phone and call. I'm old school in that regard. And yes. I know how sensitive, business owners are with regards to their information and the need to be taken seriously in portraying or describing, or just sort of, trying to put that message across that, look, I have something new and this is what I need to do. So picking up the phone to call is also one of the best options for me.
That sounds great. And you can find out her contact information as well on her website. We don't want to give that too much out on the interwebs, but we want you to make sure you go over to her website, and that way you can find out a lot of details about her educational background, and everything in between. So make sure you reach out to her ASAP, sooner rather than later. Your ideas matter.
Yes.
Now we're going to give Attorney Allgaier a moment to sip her coffee and me to get some water so we can hydrate before we go into the next session here on the show. So enjoy this commercial break and we'll be right back. Okay, everyone, welcome back to the Educated Natural Podcast. We are here with none other than my featured guest of today's episode, Attorney Fraline J. Allgaier. I'm so excited to have her here. Listen, if you missed the first half of the show, hit that rewind, replay button so you can make sure you catch up on all the great nuggets she has dropped so far as it pertains to your intellectual property, more specifically, patents. So if you are an inventor out there and you have an idea that you need to get protected, wait no longer. Contact her right now. Fast as you can run. Matter of fact, faster than you can run. Make sure you connect with her immediately so she can help you get on the road to patent success. Okay, so we've been talking about patents, but I'm reminded that Attorney Allgaier hasn't told us about her beautiful family. We want to know about her, and let's just get all up in her business in this section, okay? So, Attorney Allgaier, tell us about you, your family, and everything in between.
Well, we live here. We've been here in the Chicago area for about 24 years. We moved here from Texas. I have 3 children, and one finished college, Indiana University. My son was a cadet at West Point, but transferred to the University of Illinois. And I have one girl, 17. She's in high school. She's a junior in high school. Yes. So 3 children and and a loving husband.
Now, you told me during our pre-talk that your husband's a doctor.
Yes.
What field of doctor is he?
My husband is a neonatologist. So he, obviously did a pediatric residency
Right.
and is
Okay.
now a neonatologist. And we met actually in Texas. I was a research student at Baylor College of Medicine in Houston, Texas, near Texas Southern University, and that's where we met when I was in college. And he was had finished residency and was working on his fellowship in neonatology, and that's how we met. And we've been together
Wow.
since. Yes.
So how long have you all been married?
We've been, I would say, more on dating. We're married, but been together for about, I would say, 29 years. Yes.
Nice. Wow, amazing. Congratulations.
Thank you
Now,
so much. Thank you.
be- being that I have women that are single on my show, this is going to be their shot. Being that you are married to a doctor, does he have any brothers for the single ladies?
He has a brother, but I don't think this brother is available.
Okay.
Yes, he's equally
So, ladies,
intelligent. He's also a doctor, psychiatrist, but I don't think he's available. Yes.
nice, nice. Okay, ladies, y'all can stop trying to contact me when y'all see this. She's married to a doctor. Does he have any brothers? Because that has happened before here on the show, Attorney. People have seen my guest and was like, do they have any relatives that, because good gracious, I'm looking and I'm like, no. So,
Yeah, I've tried to make him available. He's not available. Yes.
well, that's great. I have two brothers. Anybody want them? I'm just playing. They're going to get me for that. They're so going to get me for that one. But yes, I am honored to have you here and to learn so much about your family and your wonderful kids and your practice. How did you know it was time for you to go independent and start your own practice? Because that seems like a big step.
I knew that my clients, I knew I would have clients. I knew
Right.
that, I could have the independence, most importantly, the independence. And as a mother, of three children, I think the independence is priceless. Ownership of my business, my brand. So the first thing I did was to obviously protect my brand because I knew that it would create something special, especially for as an African American, understanding, how we are in terms of business and our style, of innovation and of
Right.
interest in business. I mean, I knew that my clientele wouldn't just be African American, but initially I thought for sure I would have a substantial amount of business owners and inventors, to take advantage of my expertise. So I knew the independence would be profitable.
That's great. That's a great thing because I'm sure you probably get approached and contacted by so many people. So my next question kind of goes into what you just said.
Mhm.
Who do you typically work with? Like some attorneys only work with corporations and some only work with small business owners and so on and so forth. Who do you typically work with?
I would say that the majority of my clients are, I would say, small businesses.
Okay.
I have a good amount of individual inventors, a good number of corporations, but small businesses,
Okay.
are my clients. For example, owners of, I would give you a typical would be, for example, the owner of a food chain, for example,
Okay.
selling specialty type foods or teas, drinks, things of that sort. So small business owners would fit right in the middle, of an average client or that would call my office for, let's say, a trademark or to protect something that they're selling. Yes.
Okay. For those that are just now tuning in who may not be familiar with what patents are, there seems to be a lot of confusions when it comes to the different pillars of intellectual property from copyrights, etc. Can you please break down the difference between the pillars of intellectual property for those who may not be familiar with what all of this means?
I would say, if I were to clarify anything, I think for patents, let's say, it's fairly straightforward. I think most people would understand that a patent could be any new, for example, a new article of manufacture, an article of manufacture with a new style of clothing or small mechanical device or handheld device or a new type of alarm system or air conditioner system or anything, even something related to something that you can use. that would be patents. But the most confusing, I think, for most, I would say, people looking to protect something would be trademark. I think just knowing or understanding what can be trademarked, how to present a trademark to the trademark office,
Mhm.
how to obtain trademark protection, and for the trademark office to meet you where you are in terms of your preparedness to use that trademark, and also to prove use of that trademark, I think becomes the most confusing for a lot of people. They might not have an invention, but they might have a trademark in the form of, for example, words. Or some people might associate trademark with a design of some sort, where the McDonald's Golden Arches. But how
Right.
does the McDonald's Golden Arches relate to a word or a design? So there's always that confusion as to what to protect, when to protect it,
Right.
how to protect it, and what do I need to do to prepare myself for that protection. And how does the trademark office follow? Is the trademark office involved in what I'm doing with this trademark? How do they know if my samples are authentic, if my website is authentic? Is my social media page enough? Is Instagram enough? Are the products shown on my Instagram page enough? So there is a confusion. I think the most confusing would be trademarks.
I agree. I
Yes.
agree.
Yes.
Because even just researching trademark just for
Yes.
my own
Yes.
knowledge base, yes,
Mhm.
there's a lot of confusion with
A
trademarks.
whole lot of confusion, with regards to patentability. You can hold an object in your hand. Let's say
Right.
you have, headphones or something. You have it in your hand. You're looking at it, and you understand how it works. So there's a finality in that. In terms of trademark, and there's always something coming in from left field. I thought my samples were enough, or I thought this was enough, or that, or I thought I can do it by myself.
Right.
It looks pretty straightforward, but it has its own, levels of complexity. And I would say that's the most confusing.
Now, would patents be like on the more expensive scale as far as protection and cost versus, let's say, trademarks and even copyrights?
Patents can be 20 times more expensive than, I would say, than the trademark. Yes.
Whoa.
An average patent attorney in the United States can be anywhere from $750 to $1,500 an hour. And put it this way, a utility, let's say small, you invented a pencil and
Right.
you're coming into the office, an average patent attorney would charge would give you an estimate for at minimum 20 hours to 40 hours to write up a patent. So those are the average. So for a trademark application, I believe the average price for a trademark application could be anywhere from $2,000 to $3,000. So I would say it's about 10 times more expensive than filing for, you know, as far as I understand, what the average business owner inventor would pay for in the United
Right.
States.
So how many patents with those prices, how many patents would you say you do like in a year?
I would say 20 or so. I would about 20 patents a year, and that's 10% of clients. I would say moving forward, between 10 to 20%. So I would have been
Hold on.
introduced to at least 80.
Your internet kind of went out just for a second. Can you repeat that?
Okay, I would say, for example, 20 patents filed per year is
Okay.
more a result of a sort of a 10% decision, of inventors deciding to move forward. So I would have been approached by 50 to 100 inventors that one year with regards to, moving forward with
Right.
something or another. Yes.
So everyone, pay attention. If you're thinking about filing a patent, make sure you have your coins all the way together.
Or at least an understanding of what the process,
Yes.
would be. So we're talking about corporations. We can also talk about what it would look like for realistically, right, for an individual
Right.
inventor. Yes, who is differently positioned financially than, a corporation.
Right. Right. Now that we know that you're located in the great state of Illinois, are you able to help people outside of Illinois, like on a global level with
Okay,
patents?
so thankfully, patentability, the concern of whether, a client's idea, whether it's trademark, copyright, or a patent, these are all federal questions. So an attorney can work with clients throughout the United States and be contacted from clients in other countries to be able to prosecute patent, trademark, or copyright applications. So I work with clients not just in the Chicago. Actually, a majority of my clients are outside of the Chicago area.
Okay.
I receive contact from clients all over the world and also throughout the United States on a regular basis. And they all have the same question, can you work with me? Because I went down the street to this attorney, I saw a law office. It's not just any law office that can help you. It's, especially with regards to patentability, it's a specialty. So you do have to work with a patent attorney, and that patent attorney can live anywhere in the United States. It's a federal process.
Well, everyone, you heard it here first. If you have an idea and you want to patent that idea, she is definitely available to work with you. So what are you waiting for? Go to www.allgaierpatentsolutions.com. Right there on your screen, those of you that's watching us on YouTube and wherever else the video is available at. And for those of you that are listening to us on your favorite podcast episode, make sure you check the description box for all of her information, because you don't want to delay. Your ideas need to be protected. Your intellectual property, period, in today's marketplace needs to be protected regardless of the cost, because if it means that much to you, you want to protect it. I've always told people you have to look at your inventions, your slogans, whatever it is you want to trademark, copyright, patent, trade secrets, whatever it is you want to protect, you have to treat it almost like your children. What level are you willing to go to protect your children? You have to look at your intellectual property in the same way, because if you don't protect it, someone will feel that it is okay by you, that they can go and copy it, confiscate it in any way possible, especially in today's marketplaces in the social media era. So make sure you're taking the appropriate steps to protect what belongs to you. Attorney Allgaier, we're in the last 5 minutes of the show, and I want to give you an opportunity to speak to those possible college students, maybe even high schoolers that may be actually interested in intellectual property law. What advice would you give to those students that may be listening to this episode?
I would advise those students to reach out, to patent attorneys in their area. Don't be afraid. The USPTO holds a database, and it's searchable by state patent attorney listings. So if you visit the USPTO's website, there's a list of attorneys listed on those websites by state. You should feel the emails are provided, work locations are provided. Feel comfortable reaching out to those attorneys and seek out advice on what the process is. Seek out a mentor, talk to someone on a regular basis. Do not feel discouraged if someone doesn't return your email or return your phone call. Most patent attorneys are busy.
Yes.
They have work, obligations, requirements with regards to how they spend their 8 to 5 working for especially bigger firms. So, take that into consideration, but don't feel discouraged. Reach out to attorneys, find a local inventors organization in your area, find out how you can volunteer to start learning the process, to start interacting with inventors, to see how they carry themselves, what their interests are, as what you mentioned earlier, how they value their intellectual property, how they treat it. And you will find that most inventors do indeed carry around their IP like children.
Yes.
They spent a tremendous amount of resources, some inventors, to create the ideas. I would hate to say some later stage inventors, some older inventors, sometimes cash out retirement funds, to build. So we're sensitive to that, to this reality as it comes to inventors. The sensitivity of the nature of what they have and how they value these ideas. So feel free to volunteer, in your area, a local inventors organization. If there's not one in your area, find one, reach out to the directors and see, perhaps you can join in on Zoom calls, join in on their weekly meetings and learn, what will inventors do with the idea, especially individual inventors without a LLC or a company. What do they do with the idea? How do they get these ideas to the marketplace? So I would say for a high school student, it's a good opportunity to also be innovative in terms of how to help, or come up with creative ideas and marketing, not just patent attorney work, but also how to, what's the ultimate, the idea is to make money, from the product. Yes.
I am super excited that you took the time out of your very busy day to spend it here with me, the Educated Natural, on my podcast, the Educated Natural Podcast. I am so honored. The nuggets you have dropped, the level of information you have given out today has been so phenomenal that I can't even find the right word to even describe it. But I am so honored for you just to take the time to educate us, because that's one thing that I absolutely try to drive home with my listening audience and people that I meet on an everyday basis, the importance of education. And Attorney Allgaier, you have done just that. You have educated me. I know you're going to educate the audience. You have made me want to go research and read even more. And I always tell people I'm always a student. So I absolutely thank you for taking the time to educate us today.
Thank you so much. Thank you for having me.
Absolutely. Any final words you would like to give out to the audience today and let them know once again how they can contact you?
Yes, my website, allgaierpatentsolutions.com, and just pick up the phone and call if you'd like to schedule a free consultation. I send you an NDA, get your email address, send you an NDA to sign, and we can talk about your invention. Yeah.
Well, thank you, everyone. Make sure you contact her at her website, www.allgaiersolutions.com. And if you're on social media, which I know a lot of you are, make sure you follow her on whatever social media platform, from Facebook to Instagram. She is really blowing up over there on Facebook. I saw your page the other day. I said, oh, go ahead. Oh, but I do, as a media person, it would behoove me to ask you, you have to make more videos. You're just too beautiful not to.
I'll try. I'll give it a try. It takes a lot of time. This is perhaps something, that I could use a young student to do. I've had students approach me to help me out, making videos here and there. So thank you so much. I've seen quite a few of your videos as well. So you've done well on your end, just the same. So thank you so much. Thank you.
I'm gonna have to talk to Jay. I'm gonna have to tell Jay to come over there and pinch you and say, look, get your sister on camera.
Exactly. He helped me as well. Yes, Jay, he helped me as well. Yes.
That's great. That's great. Well, I thank you. I thank you. Thank you, everyone that's tuned into the show. I encourage you to share this out. If you ever want to reach out to the show and you would like to sit right here in the same seat with my featured guest today, all you have to do is go to www.theeducatednatural.com, hit that contact link, reach out to me. We will have our discussion and we will see about getting you on the show. As you know, this is the Educated Natural Podcast. Every new episode is released all over the podcast platforms every Thursday afternoon, and every show has you in mind. And of course, we make sure that we give you the information you need in a timely manner that you need it, and you can apply it not only to your business, but to your everyday life. Until the next time we are allowed to come together, remember, be sown, be rooted, and above all, be blessed. Stay educated, everyone. I'll see you next time. God bless.
Thank you.